Hello, my name is Afifah binti Muhammad Sharif 264805. So I will present about our assignment with the topic Proximate Cause, the general principle and its exception. So first I will give the definition of proximate cause, and second I will give the definition of peril. What is proximate cause? Proximate cause is how the damage occurred and whether the damage arose from the insured peril. As stated in the case of OC and Scottish Union and National, proximate cause has been defined as the active, efficient cause that sets in motion a train of events which brings about a result without intervention of any force, started and working actively from a new and independent source. Under common law system, to determine whether the policy will cover the damage occurred or the loss suffered by the insured party, it will depend on the peril that has been chosen as proximate cause. If the damage or loss happened due to the peril that has not been chosen to be the proximate cause, the loss will not be covered by the insurer. So, peril means cause of loss. It is the event which result damage to the property, items and belonging of the insured. Example of insurance perils can be fire, explosion and theft.
Hi, my name is Choon Kiat and my metric number is 264462. My part for our group assignment is the chance of events approach, which under general principle of our group assignment, proximate cause. So I'm going to present my part here. So normally if there is only one cause of loss which result the happening of the loss, the insurer will be liable for the loss. If the cause is covered or is the insured peril in the policy between the insurer and the insured. However, if there are two consecutive causes of loss, the first cause is, in general, is proximate cause of loss. However, but there are two exceptions to the general rule, which the first is the unbroken sequence or direct chain of event, and the second one is the broken sequence, or what we call is the interrupted chain of event. So in order to determine the proximate cause, the chain of events must be observed closely, which leading eventually or ultimately to the result, and in such events, whether there is a direct or interrupted chain of event, and the cause proximate to the result must be established. Under unbroken sequence or direct chain of event, the first event cannot be held as the proximate cause, since the loss is not direct, but it only leads to the happening of the second event which caused the loss. So in other words, if there is no happening of the first event, the second event will not occur as well. And so it is merely facilitates the first cause is only facilitates the occurrence of the second cause, and therefore the latter is the proximate cause in question. So in an unbroken chain of event, the accepted peril and the insured peril must be separated. There are two reasons behind. The first, if an accepted peril happens before the occurrence of the insured peril, the loss caused by the insured peril is the direct and natural consequence of the accepted peril. Therefore, there is no liability on the part of the insurer. And the second one, if the insured peril is followed by an accepted peril, there is a valid liability in which the insured can claim from the insurer for the loss which he suffered. For example, a drunk driver accidentally crashed into a wall, which the loss of wall in the insured policy is not covered, so it is an accepted peril. Ejected to the electricity box of a house, and the broken wall fell inside the house, damaged the electrical wiring and cause a fire in the house. And in this example, the insured bought a fire policy, so if there is happening of any fire, it will be covered. So the insurer in question is only liable for loss resulting from the fire instead of the wall, because there is not covered in the policy between the insurer and the insured. In the case of Color versus River Valley Mutual Insurance Co., the facts was that a passenger who owned a personal accident policy left a cab without paying the fare of the travelling. The driver demanded the payment, but the passenger refused. And in the altercation between the passenger and the driver, the passenger was killed. The court held that the events following the failure to pay the fare by the passenger did not break the chain of causation. Under broken sequence or interrupted chain of event, there is a legal maxim, which is the novus aetas indiveniens, which bring the meaning of where a human act breaks the chains of causation and the second event is an independent and separate event, which happened between the first event and the loss. Therefore, the second event in question is the proximate cause of loss. When the chain of causation is broken, the first cause will automatically lose its identity and efficiency, followed by a new and intervening cause will then develop, bringing about the result. If there is no accepted peril involved, it is possible to separate the losses, and the insured is liable only for loss caused by an insured peril instead of the accepted peril because the accepted peril is not involved in that situation. However, in a situation where there is an accepted peril, the subsequent or consequent loss caused by an insured peril is a new and intervening cause because of the interruption in the chain of events which give rise or affects the insurer to be liable for the loss caused by the insured peril. So, for instance, the insured had a policy covering the breakage of the main door of his house, and a strong wind suddenly caused the main had caused the main gate ajar, which opened a bit, and a thief broke into the house by breaking the main door and had stolen some valuable belongings of insured. It was undoubtedly that the remote cause of damage to the main door was because of the strong wind, but another factor, which is the thief broke into the house by breaking the main door and stolen some belongings of insured, intervened. So the proximate cause of the damage was the theft, and the insurer must be liable under the policy. In the case of Russo versus John Doe, which the case in the year of 2009, the fact was that the claimant in question who owned the personal incident insurance got injured in drive-by shooting, and he decided to claim from the insurance company. And the court held that drive-by shooting was a distinct and intervening act completely independent from the use or operation of the van, and therefore the insurer was liable for the loss caused by the insured peril. So it comes to an end of my presentation. Thank you.
Assalamualaikum and hi, I bid to Dr. Nazli. I am Muhammad Nabil Aiman bin Muhammad Nasir, matric number 265028, and today I will be presenting on part of new intervening cause regarding the topic of proximate cause principle in insurance law. So, moving for the first part. Okay, as we know, the chains of events is one of the crucial part in determining the proximate cause. However, we must realize that this chain of events had a possibilities to be broken, as there might be new intervening cause exist, and this new intervening cause is not the natural end result of what had happened before the thing occurred. This means that there will new event occur, and this event is independent with the previous event. So when this thing happen, it will lead to two conditions. The first condition, if in that situation no accepted peril is involved, the insurer will be liable for loss caused by the insured peril. However, if in that situation an accepted peril is involved and it happened before insured peril, the insurer is also liable, but he will only liable for loss caused by the insured peril, but not for the accepted peril. So this means that there will be a valid claim for loss that caused by insured peril if the excluded peril is followed by the occurrence of an insured peril. This means that the first peril must be an accepted peril followed by the insured peril, then there only will be a valid claim. However, if an insured peril is followed by the happening of an excluded peril, the claim still will be payable, but it will exclude loss or damage caused by the excluded peril. Okay, this principle can clearly be seen applied in two cases I will mention later. And the first case is case of Marsden against City and County Insurance. Okay, in this case, a fire had caused a mob to gather, and unfortunately, the mob used the cover of the fire to break glass of the windows on the building in order to steal the goods. The insured, which is the owner of the building, had an insurance policy, and his policy was plate glass insurance policy that covered breakage of glass, but it excluded breakage by fire. So, based on the law, the misconduct of the mob was the proximate cause of the loss, but it was not the inevitable result of the fire. Thus, the chain of event was broken as these two events is independent, so the racist conduct of the mob which can be considered as new intervening cause. So, the court in this case had held that the misconduct of the mob was the proximate cause, not the fire, which caused the policy exception will not be applied in this situation, and the insured can make a claim to the insurer. The situation in this case of Marsden can be considered fall under the second conditions that I had mentioned before, where an accepted peril is involved and it happened before an insured peril, which make the insurer is liable for the loss caused by the insured peril, but not for the accepted peril. So, moving for the second case, which is case of Lawrence against Accident Insurance Company Limited. So, in this case, the deceased, which is an insured, had a personal accident policy, and his policy covered on deaths which effect from accidental means, but not from the injury caused by illness. One day, while he was waiting for a train at Waterloo Station, he suffered an epileptic seizure which made him fall and roll off the platform and over into the track, and unfortunately caused him to be hit and killed by a passing train. The court held that the proximate cause of Mr. Lawrence's death was the impact of the train, thus it was the accident that killed him, not the disease that he suffered before he rolled under the track of the train. So, insurer is liable for the claim in this situation. In this case, they like a special case, as it may appear as if the court had ruled based on the last event that happened and caused the death of Mr. Lawrence. But in fact, the court had considered in this case was the proximate cause inefficiency. So that's why it's a quite different case with the previous one, which is case of Marsden. So that's all for new intervening cause part. Thank you.
So today I'm going to talk about the operating of concurrent cause. What is concurrent cause? It is when two perils occur, which one of the peril is covered and another one is not covered in the policy. Whether the insurance company liable to pay for the loss of the insured if the peril is does not covered. Okay, this one, the court will look at the concurrent cause of the loss. If the concurrent cause of the loss suffered by the insured covered by the policy, so the insurance policy must pay for the loss suffered by the insured. However, the loss sometimes might be more than what the insurance company should pay because it occurred due to two perils or more. Therefore, the insurance company include anti-concurrent causation clauses in the policy. So, what is anti-concurrent causation clauses? Okay, anti-concurrent causation clauses is a powerful device for the insurance company deny the liability upon them to compensate or to pay for the loss suffered by the insured. How? Because the anti-concurrent causation clauses, because this clause limited the liability or the coverage for the insurance company to compensate for the loss suffered by the insured. Okay, for better understanding, we can look at the case of Syarikat Takaful Malaysia Berhad and Global Process System Inc. Okay, this case is about GPS who bought an oil rig from Texas. So the appellants engage with the experts from Proximate to settle down the transit. Okay, during the journey in the voyage from Texas to Malaysia, there are 3 of the rigs leg broke and fall into the sea. Okay. The expert agreed that the loss occurred as a result of fatigue cracking from the motion of the sea. However, it was nothing unusual about the weather conditions during the voyage. Okay, the issue arises whether the broken rig's leg, okay, is including in the policy or not. Whether it is due to the motion of the sea or due to the weather. This is because in the policy, it is stated that all risk or loss and damage to the subject matter insured, but excluded loss, damage or expenses caused by inherent vice or nature of the subject matter insured. Okay, this is the argument of the insurance company. The insurance company argued that the loss was resulted from the inherent vice and not perils of the sea. The court held that the insurance company liable to compensate the loss of the insured. Okay, here we can say that the concurrent cause here is the perils of the sea and not the weather. Because why? The weather is not covered in the policy. So this is about the concurrent causation. Thank you. That's all.
Okay, now I will explain about the exception of the doctrine of the proximate cause. As we all know, proximate cause is the significant or the nearest cause which result in the loss suffered by the insured and they can claim for that loss. However, there are a time when the doctrine there is an exception for this doctrine. Sometimes, the doctrine of proximate cause can be waived by the insurer by the use of the certain particular word or clause in the policy. That because there is certain particular word in the policy that has a significant effect, which will determine whether the loss suffered can be claimed or not and to what extent the claim is payable. We can see, for example, in that policy, policymaker usually include word which exclude a certain cause of loss from being claimable. We can see in a policy there is a word like except or excluding, which become the exception of that policy. Moreover, if the policymaker lists the perils, the non-listed peril will be considered as exception of which cannot be claimed by the insured. This is because it is to protect the insurer from covering loss of more than what they should cover. We can see in the case of Rogers against Whitaker, where in this case a fire insurance policy is given to cover a warehouse. However, the policy exclude warlike or military operation. Then the warehouse was destroyed in fire due to the drop of incendiary bomb from the enemy aircraft during the raid. The insured want to claim the fire insurance policy as the warehouse was destroyed by fire. However, the insurer repudiated the claim by saying that the house, even though it was damaged by fire, it is because the fire is because the drop of the bomb by the enemy aircraft, which lists as the exception of the policy. If the bomb did not drop there, the fire will not happen. The warehouse will not be destroyed. The court held in favor of the insurer as the drop of the bomb is the proximate cause and the fire is the remote cause. Furthermore, in the case of Wind Tank Pump Co. against Employer Liability Corp., Lockheed had stated that if one cause is within the word of the policy and the other come within the exception of the policy, it must be taken that the loss cannot be recovered under the policy. The effect of an exception is to save the insurer from the liability for a loss which by exception will be covered. The effect of the cover is not to impose on the insurer from something which is in the exception.
As the conclusion, it is important to identify the proximate cause of a certain loss so that the loss suffered by the insured party will be covered. However, it must fulfill all the general principles that has been set up to determine the proximate cause of such damage or loss. Thank you.